industry matters. He is a founding partner of Holon Law Partners. I hope I got that right, Max. LLP, a cloud-based firm that services businesses and individuals in the entertainment industry and other industries across the country. Max was born and raised in upstate New York, just outside of Albany, and has lived in Philadelphia, New Orleans, and now lives in Lakewood, Colorado. Tonight's workshop is Common Legal Horrors for Artists, and he'll be discussing copyright basics and how the default rules of co-ownership can cause problems if the collaborators fail to delineate their rights with contracts. He'll also be discussing the basic rights that every copyright owner holds, and how infringement claims are mailed to help artists understand the limits of infringement. Well, he'll also be discussing defenses to infringement, including fair use and de minimis. And we'll be doing Q&A after the presentation. So if everybody can hold their questions till then, you might actually get something answered before the presentation is over.
All right. Thanks for the introduction, Rob. Yeah, so go ahead. If you do have questions, you can put them in the chat, but this is going to be a slideshow presentation, and so we will not be pausing during the presentation for questions along the way, but we will be able to answer them at the end. And so now I am going to go ahead and give Max presentation ability.
Thank you for that introduction, and thank you everyone for being here. It's always nice to have a good size audience for these presentations. Having done them for sometimes groups of only one or two, it's always nice to have a bigger group here. And once we do get into the Q&A, the discussions that come from that are often pretty enjoyable and interesting. So I'm going to share my PowerPoint here and get right into it. Okay. So here's, take a second, there we go. So I originally created this presentation. I was asked by the Boulder Office of Arts and Culture to do a presentation right around Halloween, hence the legal horrors theme. And then one of the attendees from that workshop got me in touch with Longmont Artists Guild. So here we are doing it a second time. So just so you know, this is purely for educational purposes. Nothing from this class should be taken as direct legal advice for your, can people see my screen? It says screen sharing is paused. People can see it, okay. It should not be taken as direct legal advice for your specific situation. I may mention some things throughout that are sort of commonly understood best practices for certain scenarios. But if you do need specific legal advice, it's usually best to set up a consultation where you can have attorney-client privilege and confidentiality. That said, like we talked about, I'm happy to answer questions at the end. I just recommend that they be more general and not too specific to your situation, because I might not be able to give you the answer that you're hoping for. So Rob already gave me a great introduction, but just a written version of my background. I am a musician and creator myself, which is what inspired me to become an entertainment attorney. And ever since becoming licensed to practice law, I've also given these workshops to artists because I believe it's important for artists to know and understand how copyrights work so that they can speak intelligently about the business that they run, right? The works that they create have value, and it's important to know the terminology. And so that's why I do what I do. I still play music as well. I play in a few bands around Denver and occasionally get up to Boulder County and try to do a little more of that. But happy to talk about that later. So big picture, very common understanding of lawyers is that we're basically only available if something goes wrong and you need help out of a jam. But in reality, that's just one of two major kinds of attorneys out there in the world. The other side of the legal profession is people who can help you proactively prepare for building a business, growing your projects, protecting your works that help you actually avoid litigation. So not all lawyers are litigators, though many of us do have at least some litigation skills. But there's, always the option to go talk to a lawyer before you're in trouble with something, to put contracts together, to understand how your copyrights work, to get things registered, to help uh, facilitate negotiations with new opportunities so that you get the right terms in place and that all parties are protected. If things do go wrong, that's where litigation often comes up. And that's where people will go to an attorney to get a cease and desist letter or file a lawsuit. Ultimately, the goal there is to resolve a dispute. But the reason that things go to litigation is because they are so hotly contested that the parties are not able to work it out amongst themselves. So the best way to avoid that is to be proactive in your approach. And that's why I try to highlight this, because a lot of people don't even realize that there's another kind of lawyer out there that can help you be more proactive. So working with what we call transactional attorneys to put contracts together and protect your works can help you either avoid litigation entirely or at least put you in a much better position if something like litigation becomes necessary, where you'll have a lot more leverage, you'll be able to resolve disputes much faster and hopefully with a little less stress and expense. The goal,
Excuse me, Max.
yeah,
So I am not seeing a slide. I'm just seeing your screen that shows all of the slides on the left and then the legal horrors for artists. I don't see it scrolling through
interesting.
slides. I'm
Okay.
not sure if anybody else is seeing the same thing I'm seeing, but that's all I'm seeing.
So first, okay, it says this, I'm sharing my screen. So then if I put it on presentation mode, can you
Doesn't
see the
seem.
slide now?
No, it doesn't seem to change.
Okay, let me try this. What about now?
It is not changing at all. Um, Let me change it to just one participant and then give you access. Or will that not work? I'm not sure. Um,
We can try it. I can stop sharing while you change the settings.
yeah. Um, okay. Now it says one participant who can share. Okay, try it again and let's see if that helps. There we go. That looks
Okay,
better to me. Yep. All right. Thank you. Sorry to interrupt.
so everything I just said probably makes a little bit more sense now that you can see what's on the screen. There are generally two kinds of lawyers, litigators and what we call transactional attorneys. A lot of people, when they think of lawyer, tend to only think of litigators. So the takeaway from this slide is that transactional attorneys, while there is still always an expense when it comes to hiring an attorney, we can help you put contracts together and avoid litigation or get yourself in a much better position if disputes do arise. You'll have your work protected, you'll have clear terms in a contract that help you move through dispute situations much faster and easier than you would if you don't have a contract. And believe me, I do some litigation as well, and it is more expensive and messier and a lot more stressful if you don't have a contract and the relationship falls apart. So, um, along those lines, let's talk a little bit about what kinds of things can go wrong for artists. These are, the horrors that we're here to talk about. Some of the most common issues that I have seen obviously involve payment. Sometimes people don't really have a clear understanding of exactly how much is owed or when it is owed. If there are multiple installments, sometimes there can be confusion over whether something is a payment for services versus just a deposit that may be refundable. I'm actually dealing with a case right now in Colorado State Court that has exactly that issue, where one side thought that the payment was a deposit that was refundable, and the other side thought that it was a payment for their services. Had there been a uh, more robust contract that was actually signed by all parties, there'd be a lot more clarity around that. But unfortunately, that's not how it was handled. So now they're dealing with litigation, and it's going to take a lot longer to get that worked out. Um, when you're dealing with commissions and collaborators, there's often there can be confusion that leads to disputes over who actually owns the rights to the artwork. That involves work for hire that we'll talk about later on in this presentation. Along those same lines, there can also be disputes among collaborators over how payment should be shared, or who has authority to commercialize the work in some way through licensing or other things. Um, Obviously, copyright infringement is always a concern in the world of art and other creative things that are protected by copyrights. There's always people out there who might think that they're in the clear. Maybe they have a poor understanding of the fair use doctrine, or they want to specifically rip you off, or maybe it's a big company that sees your work on Instagram and wants to use it as part of a pattern on some new trendy product. There's a lot of different instances where copyright infringement involving independent artists' works comes up. Fair use is an area that people probably rely on a little bit too much. It's a nice concept, and when it works, it's a great thing to have. And I'm glad that constitutionally we have fair use, because it helps protect the rights that we have under the First Amendment. But it's also a defense to infringement, which makes it very difficult to prove and very difficult to really rely on for commercial purposes. So it's an area that people think they're in better position than they actually are, and sometimes that can cause problems. Trademark infringement, similar to copyright infringement, this can sort of go both ways. You might have a brand that you are protecting that somebody else rips off, but in other situations, I've had clients who either knowingly or unknowingly are using someone else's brand name or using someone else's artwork as part of their business. And so there's sometimes situations where they get an angry cease and desist letter that they need help dealing with. And then, of course, the emerging and ever shifting world of AI. Just about everything involving AI is a little bit of a legal landmine right now because of privacy issues, copyright infringement issues. There's several federal lawsuits pending right now that are trying to establish whether or not certain uses of artwork by AI are a fair use. So a lot of this is not really clear yet, which always makes for potential problems. I don't have a catchy phrase for this, but the way to avoid problems generally when it comes to legal issues is to have a lot of clarity around what the terms are and what the rules are. So anytime you don't have clarity is usually where lawsuits pop up. So with all that in mind, it's helpful to have a good foundational understanding of what your rights are as an artist, so that you know what you are able to protect, how you're able to protect that and monetize it, and then, of course, how to identify when other people might be infringing on your work, or how to identify when your work is too similar to someone else's. And this is a good working knowledge to have as an artist. You don't necessarily need to be an expert at the level of a copyright attorney or somebody who works more in sort of the business side of things. But just like the analogy I always make is just like, people who own real estate generally have a basic understanding of how property rights work and how zoning and taxes work. It's usually a good idea for artists who are creating copyrights all the time to have a basic understanding of how those work. So the first thing to understand is that a copyright is a set of exclusive rights. Every individual copyright out there is actually a bundle of rights. And that's what I have here in these bullet points, is essentially every copyrighted work comes with basically 5 out of the 6 of these rights. The first three, to make copies, distribute copies, and to create derivative works, are applicable to all kinds of copyrighted material, whether we're talking visual art, film, books, newspaper articles, music, recordings, all sorts of things that are covered by copyright. They all have these core rights of the owner having that exclusivity over the right to make copies of that work, distribute copies of that work, create derivatives based on that work. Then the next three are also part of what we call the Section 106 rights, but they technically only apply to certain types of works where it makes practical sense. So for visual art, you have the right to publicly display the work. That's an essential piece of your copyright ownership. So nobody can take your work or a picture of your work or make a print of your work and decide to hang it up in a gallery somewhere or at a museum somewhere without getting your permission. Just like they wouldn't be able to make copies or distribute those copies or make derivative works without your permission. For other types of works, if we're talking about sound recordings, there is a very specific public performance right for sound recordings that basically only applies to internet streaming. And then other types of works that can be performed, like songs and theatrical performances and things like that, have a much broader right of public performance. So anytime you see a play being put on somewhere or a film being screened somewhere, there is usually a license in place from the copyright owner to give permission for that public performance. This bundle of rights is treated as property. So when you have a copyright, and we'll talk about how copyrights come into existence on the next slide here, but when you have a copyright, when you own that copyright, it is a property right. So you can possess it, you can sell it to somebody else, you can lease it out to other people. That's what we call a license in the copyright world. And it's also important to understand, and this is probably most important in the visual art context, that the copyright is a completely distinct and separate piece of property from the art object itself. So your painting, your sculpture, the physical object that your work is has the same basic property rights that, you know, this can does, or your wallet or some other just piece of physical property. Separate and legally attached to that is the copyright. And so what that means is that if you sell one of your originals to a collector, they are only getting the property rights in that object. They're getting possession of that object. Maybe if it's a very valuable piece, you could argue they're even getting title to that object, the way you would for a car or another expensive piece of property, that there's sort of this notion of title in that. But that is legally distinct from the copyright. So just because a collector purchases your original painting and hangs it in their home does not give them permission to go and make and sell prints of that painting. That right remains with the artist or whoever owns the copyright to that image. So for example, when you see famous works hung in a museum and there are coffee table books and posters and tote bags and other things like that in the gift shop of the museum, if it's a work that's not in the public domain, the reason that the museum can do all of that is because they've gotten a license from the owner of that copyright for that image to publicly display the work in the galleries at the museum and to make and distribute copies of the work in the form of prints on posters and tote bags and other things. So it's a multifaceted copyright license that allows a museum or a gallery to do something like that. And it all goes back to getting permission from the copyright owner. So all that being said, it's important to understand that there are other types of intellectual property out there. I was just talking to Rob about this right before the meeting started. Trademarks and patents are two other major forms of intellectual property that are recognized at the federal level in the United States, but they cover different things. So trademarks are used to protect your brand. So if you have like a name for your studio or a brand name under which you sell your art, or even a logo that you use to identify your products, that is protected by trademark law. There's sometimes overlap there. The logo might have unique copyrightable design elements to it, but the legal protection you get from trademark is different. Copyright protects the work itself from being copied, distributed, etc. Whereas trademark protects your rights as a business owner to use the trademark in an identifying way. So if someone else wants to use a similar trademark to sell similar products, that's a trademark infringement. Even if the products are completely different from what you are selling, meaning there's no copyright infringement involved, there could still be trademark infringement if they're using what we call a confusingly similar name or logo in the efforts of a similar business. Now, there are some variations of that in trademark law. I don't want to get too deep in that right now, but you'll see that like there's a Delta dental chain of dentist office and Delta Airlines, right? They're in two different industries, so it's not really the same thing. And that type of thing can be allowed, but when you're selling similar products or services under a similar or identical name, that's where you have problems with trademark. Copyright, the issues will come up if the work itself is copying or too similar to other copyrighted work that you have. And then patents are an area of law that protect inventions. So there's not usually as much overlap between patent and the world of copyrights and trademarks. Generally, you're dealing with patents if you're an inventor, and the patent covers what we call the useful article, so that the actual functional aspects of how the invention works, rather than a unique design. And there's always more nuance to all of these things, but I have this slide here just to really make it clear that when we talk about copyright, the terminology is not interchangeable. So if you hear someone talking about trademark, that relates to a very specific thing, whereas copyright relates to specifically protecting the works that you create. So with that said, there are specific categories of works that kind of help you get organized and oriented in terms of what copyright law protects. So on the left is the list of categories from the copyright statute, and that are also used by the US Copyright Office to sort of broadly categorize different types of works. And then on the right are examples of those categories. So the most relevant category for this group is the pictorial, graphic, or sculptural works. This is a pretty broad category that includes all forms of two-dimensional and three-dimensional art. And so when you go to register your copyright, when they ask you what type of work you're registering, this is the category that your work would fall into. If you're registering songs or screenplays, those would go into what we call a work of performing arts. So dramatic works and musical works kind of make up that broad performing arts category. Films and videos and other things like that are considered audiovisual works. Literary works is probably one of the broadest categories because it covers not only creative writing, but also all kinds of writing that has some degree of human creativity. So technical writings and instruction manuals and exams and all sorts of other things can be protected by copyright as literary works. And in the world of two-dimensional and three-dimensional art, that also applies to things like technical drawings, where there's an element of human creativity. There generally is copyright eligibility. Things like architectural designs, choreography, and sound recordings are also covered by copyrights. So it's a pretty wide range of things that can be made via human creativity that are covered by copyright law. So in order to get to that point, you have to show that you have an original work of authorship. It does not need to be the most novel or unique thing that's ever been created, but there needs to be at least a minimum degree of creativity. It needs to be a human author as well. That's not technically in the law, but that is the longstanding Copyright Office policy, and it's now coming up a lot in all of these conversations about AI created artwork. And it's not enough to have come up with this work of authorship, but you also need to write it down or fix it in some way. So if it still just lives in your head, then it's not going to be eligible for copyright protection. It needs to be put down on paper or some digital equivalent of paper and in some kind of tangible form, because really what copyright protects is the expression. It does not protect the underlying concept or idea. It protects your unique, specific expression. So what your copyright attaches to is that particular expression, right? And so along that line, copyright comes into existence the moment you have fixed your work in a form of expression. And the whole idea here is that as a type of legal protection that gives you essentially monopoly control over that work, nobody else can use it without your permission. So you get this monopoly over this very specific piece of property. Copyright law is only going to protect the things that actually could be copied. So if it hasn't been written down and nobody has some way of really seeing and perceiving what the work is, then it can't really be copied and there's not really any legally recognizable harm there. But as soon as it has been fixed in the medium of expression, now it's out there in the world where somebody could come along and see the work or the writing or whatever it might be and be able to copy it. And so since it's now susceptible to another human copying it and using it for their own purposes, that's the moment where legal protection starts. So it's a common misconception that you are sort of in this weird unprotected limbo state if you don't register your copyright, and that's actually not true. Registration is not a prerequisite to having that substantive ownership of a copyright. It's very important for other reasons. It gives you significant benefits if you end up in a lawsuit. And so for that reason, I often recommend it. It's basically a very cheap insurance policy. It's a one-time fee. If you need it, it's extremely helpful to have. But if you don't need it, you're not really out of pocket that much. But the point here is that you actually have those rights, the 6 rights here that are listed under 106. You have those as soon as you finish your painting or your sculpture or your poem or whatever it is that you're creating. Now, some important terminology here. The author, and this is a term that's used in the copyright statute, it's used in copyright court cases. It's a very important technical term in the context of copyright law. The author is the person who actually creates the work. The owner is the person who actually controls that copyright. So most of the time, the author is automatically the initial owner of the rights. There's very few situations where the person who creates the work is not the author. That's where work for hire comes in. And then there's other situations where the person who creates the work is still considered the author, but then immediately sells their copyright or transfers that ownership to somebody else. So in most situations, the author and the owner are the same person, but they are two very distinct statuses that you can have with respect to a copyrighted work. And so they can be separated. The author and the owner don't necessarily need to be the same person, because the author can always transfer their rights to someone else. That's one of the benefits of it being a piece of property, is that it's very easy, legally speaking, to do that. It doesn't have a lot of complications. If you have multiple authors, multiple collaborators, then you're often in a co-ownership situation. And that's one of the areas where problems come up pretty often. So I have a whole slide talking about co-ownership. Before we move on to that, I just want to also note that there are limits to what can be protected by copyright. So basic shapes, the sort of fundamental building blocks that people use to create artwork, cannot in and of themselves be copyrighted. Nobody owns the copyright to the shape of a square, for example, right? Also, sort of the concept behind a painting or a sculpture or a film is not what is protected. The unique expression is protected, right? And so That's kind of a tricky concept to wrap your mind around sometimes, but the idea is that you can make your work what we say is sort of more protectable by making it increasingly unique, right? So in the written context, we see this a lot in the film world. If people have really unique characters, then the characters themselves are eligible for copyright protection beyond even just the story that has been written about them. And that can be really useful in building things like franchises and comic books and other things like that, right? Because then you have this strong piece of copyright material that can be dropped into new derivative works and still enjoy the copyright protection of that original. But that doesn't mean that somebody can get a copyright in the concept of like a superhero action story, because that concept is not what copyright law is meant to protect. So, talked about co-ownership. There's a couple important things here with co-ownership, and I want to go through this kind of slowly to make sure that it's very clear. So, the first thing to understand is that the copyright statute has several provisions in it that are essentially considered default provisions, which means that if you don't have a contract with your collaborators or with the person who's hiring you, you have some kind of relationship with another person where a copyright is at the center of that relationship, and you do not have a contract, there are several default rules in the copyright statute that are going to control what happens in that situation. You can always get out of those default rules by using a contract. And so this is why we recommend contracts so often in the arts and entertainment space, because these copyright co-ownership rules will kick in whether you know it or not. And if you don't understand how these rules work, they can actually work against you in certain important ways. And so contracts are very important for shaping the way you interact with the copyright, whether you own it, whether you have a license with somebody else, whether you co-own it with somebody else, whether someone has some sort of limited access to it, whether there's money owed for use of it. There's all sorts of things that become a lot clearer if you spell it out in a contract. So with that all being said, the default rules to understand, the first one we already went over, which is that the author of a copyrighted work is automatically the initial owner, unless work for hire applies, and we'll talk more about work for hire on a separate slide. But setting that aside, if no work for hire, the author is the initial owner. If there are co-authors, multiple people working together to pool their talents and create one cohesive work at the end of their efforts, then they are automatically going to be co-owners of that copyright. Now, that's not quite the same thing as somebody creating something and then someone else coming along later and adding something to it or sampling that original work and incorporating it into their own. That is not a co-authorship situation. There needs to be a subjective intent among all the collaborators to create something together. And if that is there, and they did in fact create one sort of unitary work at the end of this process, that's when you will have a legally recognizable co-authorship situation. So if you have that, they're going to be automatically co-owners. Co-owners own that copyrighted work in equal proportional shares. It's another default rule, so I probably should put it on a separate bullet point. But if you have two people and you don't have a contract, you're going to own that copyright 50-50. If it's three people, it's going to be 33 and a third each. Four people, 25% each. So even if you think, oh, this person only contributed, 5% of the work, and this other person actually contributed the lion's share, and they actually are responsible for 80% of the work, that none of that matters if there isn't a contract that actually shifts the ownership percentages to match whatever the authors think that each respective contribution is. Without that contract, the default is going to be equal shares. Now, along the lines of equal shares, just like co-ownership of a house or some other real estate, all the co-owners are entitled to use the entire property. So that means that even if you only own a 25% stake of a copyright, you can still go out and license out the work. You do not need to get permission from your co-owners for most scenarios. Most situations involve non-exclusive licenses. And so those can be issued by any of the co-owners acting on their own. The only obligation that co-owners have in that situation is to pay the other co-owners their share of the money. But they do not need to go and get their permission. Now, if they want to sell the entire copyright, that requires all the co-owners signing off. If they want to encumber the copyright with an exclusive license, meaning nobody else can use it during the term of that license, then they need all the co-owners to sign off on that. But a lot of licenses out there, a lot of money-making opportunities for copyrighted works come in the form of non-exclusive licenses, and co-owners do not need permission to enter into those. So if you have a situation with collaborators and some of the collaborators can't really be trusted to properly collect the money or charge the right fees or pay the collaborators their fair share of the fees, then you probably don't want to get into a situation without a contract with that person, because they're going to be able to go and do whatever they want. And that's often not what people think or assume is the case when they have collaborators. So it's important to recognize that this is the default rule and is going to happen unless you use a contract. That's one of the legal horrors right there. The last default rule to understand, and this is actually one that cannot be changed, but is still important to understand, is that co-owners cannot sue each other for infringement because they are all owners of that copyright. So their use of the copyright as the owner can never, by legal definition, be infringement, right? And so you can't sue one of the co-owners just because you didn't like what they did with the work and call it infringement. You can sue them for an accounting of money that they might owe you for that commercialization, but you can't really stop them from using the work if you don't have some sort of contract that dictates the terms of how that work can be used. So all that being said, that if you get into a contract, you can divvy up the percentages in the copyright however you want. You can give one person 1%, keep 99% for yourself. You can give yourself what are called administrative rights, so that your other co-owners, even if they're going to retain some piece of the copyright, don't have the legal authority under the contract to go out and issue licenses for that copyrighted work. We call those administrative rights. So that can be a really important thing to address in these contracts. And then, of course, you can also define parameters on how the work is permitted to be used. So if you and your co-owners decide, you know what, I don't want to license out these songs for, any violent video games. We can license it out for any other type of video game and any other type of movie, but this one thing, we just don't want to ever use our music for that. If you have a contract that specifies that, then all the parties to the contract are bound by that. You can't issue a license that violates the terms of that contract. So you can take that example and apply it in a lot of other ways, right? If you have co-owners on a painting and maybe there's certain types of museums or certain types of galleries that you refuse to work with, you can specify that in these contracts. You can specify just about anything in these contracts as long as it's not illegal. And so that's a really key piece of controlling your works that depends upon an understanding, or at least a basic understanding of copyrights, that I always want to really make sure I impart upon artists. So a couple other things to know. We talked about human author, talked a little bit about originality. We talked about when the copyright begins, it's that moment of fixation. And we also talked about how registration is not technically required. However, you do need a registration or proof of registration if you need to file a lawsuit. So you never know when that might happen, but if it does come along, you'll need to be able to show that you actually have a registered copyright before you can start a federal copyright infringement lawsuit against someone else. Then once you're in that lawsuit, There's additional benefits that come from registration, especially if registration is made very timely, shortly after you publish your work, then you get certain benefits. But if you wait a really long time to register your work, you can actually lose out on some of those benefits. So I often recommend, sort of best practice is to register your copyrights, because it's not that expensive in the grand scheme of things, and the benefits that you get are well worth it. And B, do so either before the work is registered, because registering in that unpublished state will pretty much guarantee that you get the maximum benefits from it. Or if you're shortly after releasing the work publicly and making it available for sale, what we call publication for copyright purposes, then you have a window of about 3 months to get your work registered and still capture all of those benefits. If you're outside those 3 months, you will miss out on some of those benefits. If you're well past 5 years, then you will have, the bare minimum of being able to file a lawsuit, but not really a whole lot of other benefits from registration. I can talk more detail about that, but that's why I usually just recommend register and do it early. The last point I want to touch on here before moving on to the next topic is that there is a lifetime or an expiration date for copyrighted works. So if it's an individual author, a human creates this, then the work has copyright protection for the author's entire life, plus an additional 70 years after they pass away. So while you are alive, you always have copyright protection over your works. You never have to worry about that. There were older versions of the copyright law. If we were living in 1910, it'd be a very different situation, but we're not. We're living under a more modern version of the copyright law that automatically grants you copyright protection from the moment of fixation and gives you protection for your entire life, plus an additional 70 years so that your heirs can enjoy the benefits. If it's a corporate author, which happens in the work for hire situation, where a company is actually considered the author of the copyrighted work, then a company theoretically could live forever. And so there isn't a natural death date that we can use as the marker here. So instead, works that have a corporate author, like a Disney movie or Mickey Mouse or something like that, the duration is 95 years from the date that the work is first published, or 120 years from the date of creation, if it's something that was essentially kept on the shelf for a long time before being released. So basically, whichever of those two is shorter. Just want to touch briefly on the AI topic, because that's always a common concern. As I mentioned earlier, U.S. Copyright Office generally does not allow registration of things that are not created by humans. There were cases back in 2018 involving a monkey that got a hold of a smartphone and took a selfie. And that was actually brought to a federal court, and the court applied the US Copyright Office's guidelines and found that this was not a human author, and therefore there is no copyright. So the Copyright Office is taking the same approach with AI created artwork. There's obviously a lot of situations where it's sort of a blend of human creativity and AI assistance, depending on what tool you're working with. And essentially what the Copyright Office has said is that it will not allow registration of the portions of the work that are created by AI. So if you have an AI assisted work, the only thing I can really tell you so far is to emphasize the fact that it is human created, but it's going to be a little tricky. There's actually a Colorado-based artist that's been fighting the Copyright Office for several years on this topic now, and it's still not really all that favorable to AI-assisted artwork. It is expected that the Copyright Office will evolve in its policy over time as it comes to understand how AI works better, and as AI tools evolve, and as we as a society kind of come to better terms with how it fits in with everything. It's entirely possible that they will, eventually shift their policy stance on that and allow registration of certain AI things as, essentially AI functioning as a tool, right? Hard to say for sure, but there were a lot of similar conversations like this back when photography cameras came along. And now we pretty solidly see those as a tool, and that the photographer is an artist for just using a tool. AI is a little bit of a different story, but it's possible that it'll eventually come to be seen that way. The other piece of AI, which isn't really on the slide here, but just I want to make note of this, is that there's sort of the other side of it. This is sort of what we call the outputs side of it. And the inputs side of it is AI tools using existing artwork as training data. And that, in my mind, and in the minds of a lot of copyright experts, is a pretty cut and dried situation where if you use copyrighted material, it usually requires a license. And so when these AI companies are using copyrighted material to train their AI models, there's several lawsuits involving AI music companies, AI artwork companies, AI text companies, and they're all essentially doing the same thing. They're ingesting this copyright protected material, using it in some way that arguably should require a license and should be paid for, because then it is ultimately being used to create this AI tool that is being sold for money to other people. So that's still sort of making its way through the courts. There's a lot of arguments from these tech companies that are using copyrighted material in large quantities that it's a fair use. And so they're bringing up these fair use defenses in various different federal courts around the country to see where they can get that argument to stick. And eventually we'll have enough appeals from these cases that maybe one of them will work its way up to the Supreme Court in 10 years or so. And then we will have really definitive AI copyright guidelines. But for now, we are living through history and figuring it out as we go. And it's certainly a complicated and challenging area, but definitely interesting to talk about as well. So since we talked a little bit about the importance of contracts earlier, I wanted to just touch on sort of the way that contracts can function in sort of a big picture way, which is that essentially there's two major phases where I see contracts coming up. One is sort of at the front end of a project. If you're working with collaborators, if you're getting hired by someone to create something, there's usually contracts on that front end of the project to establish the terms of payment, the dates of either when the work is going to be created or deadlines for delivery. If you're hiring assistants, you're usually doing that before you're getting started with a project. So there's sort of that phase, right? And there's a lot of different names that those contracts can have. That part isn't really as what's important. What's important is that, broadly speaking, on the front end, you're usually trying to define the parameters of payment. And if you're doing it right, hopefully also discussing what's going to happen with the copyright ownership in the work that gets created from this relationship. So if I'm getting hired by a large institution to create a sculpture that's going to get permanently installed in their front lawn or something like that, I want to have some language in there, not only about the deadlines for delivering this to them, but also who owns the copyright to this sculpture when I finish this project, right? And so that's an important thing that usually needs to be addressed in those contracts on the front end of a project, so that there aren't disagreements and confusion and disputes and spending way too much money on lawyers after the fact. Now, if you've gotten through a project and you now know for sure that you own the rights, or you have a clear understanding of who owns what or who has the licenses to what, then there's sort of a separate pool of contracts that you're usually dealing with to commercialize the work. So issuing licenses to third parties, selling the work to a larger entity that's able to do something with it. Maybe you've created some designs that a clothing company wants to incorporate on their patterns or something like that. All of those things are sort of the money-making contracts related to copyrighted works. So generally speaking, we're dealing with a license or an assignment. It's a little bit simpler than on the front end, because It's really usually one of those two transactions. A license is where you're retaining ownership of the copyright and issuing some permission to a third party. Assignment, you're actually selling all or a portion of the copyright to another person. You're giving up control in a mostly more permanent way than you would be under a license. So what often goes hand in hand with contracts, especially when we're talking about commissions and even when the artist is the hiring party, bringing on assistants or employees, is that work for hire usually comes up as a topic. And it's either addressed in the contract directly because it needs to be for certain legal purposes, or it's at least discussed as part of the process of onboarding the artist to work on this project. So the three major scenarios where this comes up are when the artist is hired by a third party, like a commission, a mural, a sculpture, some other painting, something like that. The situation where the artist is the employer and they're hiring a team. And then situations where the artist maybe is working full time for a design studio or some other type of company that is creating copyrighted work as part of its ordinary function. So no matter what the situation is, I want you to read the sentence at the top in bold. No matter what the situation is, if you pay someone to create artwork, that does not automatically transfer copyright ownership. It is one of the most widely misunderstood concepts in the copyright world, especially because it often involves companies and people that do not work with copyrights very often, and yet they find themselves in these types of relationships pretty often. One of my very first clients was a painter who was hired by a restaurant to do some murals for them. The restaurant knew nothing about copyright law, so they never even thought about the nuances that they would need to address in the contractual relationship with my client. And when they failed to do that, and we sent them a cease and desist letter for copyright infringement, they didn't even know that we were talking about copyright infringement. So, moral of the story is that as artists, you ultimately are the ones with the expertise around how copyrights should be handled. Sometimes you'll be dealing with parties that do also understand it, but more often than not, you're dealing with an entity, whether it's a company or a nonprofit or a government office or a wealthy patron of the arts who knows next to or actually nothing about copyright law. So oftentimes they are going to assume that because they're paying you to create copyrighted work, that they own the rights without any other strings attached. Simply handing you money and you create a painting or a sculpture or something for them, and they think that they own the rights. And that is not true. So, that being said, there are very specific ways in which the hiring party can obtain the rights. And the two major ways are either through an assignment, as we just talked about on the previous slide, where they are actually purchasing the copyright ownership from the artist or whoever owns that copyright originally, or the work for hire doctrine applies. And it's this very specific area of copyright law where if it applies, it actually makes the hiring party the author, not just the owner, but actually the author of that copyrighted work. So there are two ways that this can happen. Either the artist is an employee, basically a W-2 employee of the hiring party, and then that makes the company who hires them the author of the work. So when you look at the copyright registration for a Pixar movie or something, you see Pixar Inc. as the author, not a list of all 300 artists and illustrators and animators who created the movie, right? The other and much more complicated pathway for work for hire is when the artist is an independent contractor. And so there are some situations where even as an independent contractor, the person hiring you can be considered the author, but they have to follow very specific steps to make that happen. The most important thing is that there needs to be a written contract that includes the words work for hire in the contract. The copyright statute literally says that you need to have these words in the contract. So that's why we call them magic words. Because if they're not there, you're not meeting the statutory requirement. The other big piece of it is that work for hire with independent contractors only applies to a very specific set of types of works that are spelled out in the copyright statute. And in one of my other presentations, I think I have the whole list there, and I'm not sure I incorporated it into this one. But those categories include tests, answer material for tests, atlases, bunch of other kind of obscure things, but also motion pictures. So if you're part of a film crew, no matter what your role is, camera operator, set designer, painter, prop master, actor, whatever it is, every single person on a film production these days signs contracts that say your contribution to this film is a work made for hire. And the reason that works is because it falls into one of those 9 categories, and it's a written contract that has the words work for hire. So that's for the independent contractor, where the person who hires them is then considered the author. And the reason that hiring parties want to do this is because if they can be considered the author from the beginning, then they are automatically the owner, and no further transactions are needed. They don't need to go back to each of the people that they hired and get them to sign copyright assignments or copyright license agreements, because they've already secured copyright ownership through this very specific work for hire pathway. The easier way to do it for copyright purposes is to hire people as W-2 employees. And then it doesn't matter what's in your contract, and it doesn't even matter what type of work they're creating. But a lot of employers don't do that for other reasons. So that's why copyright law has these 2 different avenues. So the final point I'll make here, and kind of the big takeaway, is that if it's not a work for hire, so if you're not an employee and as an independent contractor, for whatever reason, the work doesn't qualify for work for hire under this second point here, under number 2, then you still own the copyright. You're still the author of the copyright. And so this is where the confusion and the disagreement often comes up, is that the hiring party assumes that they own the rights simply because they paid you as the artist to create it. But because they didn't follow these steps, the artist still owns the copyright. And the only way for the hiring party to have ownership is if they have a contract that contains a copyright assignment clause in it. So, what do visual artists need to know from this? If you are working as part of a film, then you might have a work for hire situation with the film producer who's hiring you. Almost any other situation, you are pretty much never going to have a work for hire, because visual art is not one of the 9 categories. So as a freelancer, unless you're a W-2 employee, creating paintings for a company that, produces commercial artwork or something like that, and that's your day job, just making paintings for this company. If you're a freelancer and you're asked to create a sculpture or a mural or something like that for someone, 99% of the time you are still going to be the copyright owner, unless there's that contract with a clause that specifically transfers it. So I say all this to say, this is one of the big legal horrors that comes up for artists, is employers who think they own the rights to the artist's work and act in accordance with that mistaken assumption, and don't pay the artist or don't get permission to reproduce the work beyond the scope of the initial agreement or something along those lines. And so that can very quickly turn into unintended copyright infringement situations, or scenarios where the artist should be getting additional payments or additional royalties. And as long as you, the artist, understand this, then you can know when to sort of see these red flags come up, or to know how to put certain things into your contracts. And there's a lot of artists out there who don't come to these workshops and don't know this, and they're not even including a copyright ownership clause in their contracts sometimes. But the company hiring you is almost never going to do it because they don't even work in the copyright world, right? So important to know this stuff. Just a quick note here. I don't want to get too deep with this, but sometimes the question of whether you are a freelancer or an employee is a murky one. And so courts have a test that basically asks a bunch of questions and looks at the facts to determine whether you are legally should be considered an employee or an independent contractor. Once that determination has been made, then you can go back here and sort of figure out the way work for hire should be analyzed. Most of the time, it's a little bit more clear. If you're basically working out of your own studio and buying your own materials and getting paid via invoices and 1099s and things like that, you're probably a freelancer. But if you're working for someone in a way that looks more like a day job, then you're probably an employee. So the last sort of horrific thing to talk about here is infringement. One point to really get across here is that any unauthorized use of a copyrighted work is infringement. And so what that means is that copyright infringement, the legal term for it is that it's a strict liability offense. It does not matter what your mental intent was. If you use a copyright without permission, then it's infringement. You either have permission or you don't. And so another thing to understand there is that we're not just talking about copying or emulating a work in such a way that it's too similar to an existing work. It also means making unauthorized derivative works, selling copies. Even if someone else made those copies legally and with permission, the person selling them might not have that permission to distribute those copies. So any unauthorized exercise of those Section 106 rights that we talked about at the beginning is an infringement. So there's a lot of situations where this can come up. The most obvious are where there's a direct, rip off. Someone is either literally copying something or recreating something by hand while looking at the other thing, and that's more or less the same thing. But then there's also more subtle ways that infringement can happen, where there's pieces of a work that are used, or there's a character taken from a story and written into an otherwise original, unique story. And so some of those things can get a little bit more murky, and that's usually, again, where lawsuits come up. The really cut and dried situations usually get settled with a cease and desist letter well before it reaches court. Sometimes you're on the receiving end of that. Sometimes you're on the sending end of that, right? And so as an artist who owns copyrights, it's important to understand that you need to be mindful of the way you utilize your inspirations. And if you copy things too closely, you might be putting yourself into hot water where you're committing infringement. But then also, as a copyright owner, it's your responsibility to enforce your own works. For the most part, there is not any third-party agency or law enforcement organization or anything like that that polices copyrights for you. You have to sort of be on the lookout for infringements, or if you find out about infringements, you have to take action on it. Otherwise, you run the risk of statute of limitations running out, and then you don't have the opportunity to do anything. Lawsuits are expensive and very time consuming and take a long time. And a lot of times copyright infringement disputes don't necessarily require the full scope of what a federal court can provide. And so that's why just a few years ago, the Copyright Office created a essentially small claims tribunal called the Copyright Claims Board. And it's for copyright infringement disputes where the expected value is under $20,000. So for those situations where someone rips you off and it's a $5,000 job that you should have been paid for, or a $5,000 license fee that you would have otherwise gotten if it weren't for the infringement, it might be a better use of resources and a more effective way of resolving the dispute to go to something like the Copyright Claims Board instead of spending the money on a big federal lawsuit. That being said, we usually always start with a cease and desist letter and attempt to resolve it out of court first, but that doesn't always work. Now, if you're on the receiving end of a cease and desist letter, or you've already ignored that cease and desist letter and now you're getting sued, then you have to start thinking about defenses. And if you don't have any defenses, then you probably just want to settle and move on quickly, because otherwise you're just throwing bad money after bad. I don't know how else to say it. But if you do have some defenses, there's some important things to be aware of. Sometimes works might look similar to each other, but you can prove that it is your own original independent creation. You never saw this other work in your life. You never used it as a basis for your work. You never used it as an inspiration. People have successfully defended infringement lawsuits that way. So it takes a lot of work. It requires a lot of evidence. But if you can prove that it's an independent creation, then you are not liable for copyright infringement, because you are not copying someone else's work. More commonly are what we call affirmative defenses, where you acknowledge that you did in fact infringe on someone else's work, but it should be excused because of either judicial economy or First Amendment protections. And so de minimis is this notion that the court shouldn't spend its resources handling a litigation over a tiny, tiny thing. So if you copy, a tiny trivial piece of someone else's work, it may be seen as de minimis, and it's probably not something that anyone's going to bring to court in the first place. If they do bring it to court, you can raise de minimis as a defense. Say, hey, look, judge, we know that there was an unauthorized copying here, but look at the big picture here. This was such a small amount that this should be seen as de minimis and dismissed. Somewhat related to de minimis is fair use. It is also an affirmative defense. It is very difficult to win on fair use. So I do not usually recommend that people rely on it, because the only way to establish fair use is to get sued, raise fair use as a defense, and win on that defense, which means you need to go all the way to trial or very close to trial and get to a summary judgment, which means by that point, you've probably already spent $10,000, $15,000 or more fighting a lawsuit. But sometimes it's worth it. Sometimes it's a very big deal. Sometimes it's a big project. Sometimes it very much falls in line with First Amendment protections, and you want to make a statement about allowing certain things to remain fair uses. And so if you have the resources to do so, and you can litigate a fair use defense, you basically point to either the fact that it is squarely within First Amendment protection, being journalism, commentary, criticism, or educational purposes, or in fact it qualifies as a transformative use under this very specific test that's in the copyright law. So without getting any deeper than that, you can already see that it gets pretty complicated pretty quickly. And so, the best approach is to create original work. And then you never have to worry about infringing on other people's stuff. But at the same time, you as a creator do need to be aware that sometimes, even if it's totally unexpected, there could be infringements happening with your work, and you need to recognize what your options are to enforce that, and also be able to sort of evaluate when it's worth enforcing. Some sorts of things are going to be de minimis and won't be worth your time or money pursuing also, right? So some things to think about there. So that's pretty much all for my presentation. There's a couple of resources here on this slide that help you understand copyright law a little bit better. Fair use doctrine is the whole part of the Stanford University website dedicated to it. I'm a big fan of the Copyright Office circulars as a place for resources and information. They are PDF documents that are usually no more than 4 or 5 pages long. And there are about 60 or 70 of them, all on different topics that relate to copyright eligibility, copyright registration, working with the Copyright Office over some more nuanced and unique things. And so if you're registering copyrights yourself, the circulars are a great place to get the information you need to cruise through that with minimal issues because they basically lay it all out for you. They have a whole part of their website, the Copyright Office, talking about their AI policy that's going to continue to evolve as they do more listening sessions with artist communities and enact more policy around that. And also just want to point out that the Copyright Office's website, copyright.gov, is where you go to register your copyrights. So if you're doing a Google search for copyright registration, you might get some paid ads that come up trying to sell you into using some third-party service that's going to charge you way too much. Just make sure you're actually going to copyright.gov when you register. So I want to just give a special thanks to the Longmont Artists Guild for having me here. This is a great opportunity. I really appreciate it. Great way to start off 2025. Now we can move into some questions. And if you'd like to set up a follow-up meeting with me, feel free to scan the QR code or send me an email here on the page. I can also be reached by phone, though email is usually preferred. Have a little bit of time right now to answer some questions if there's some in the chat or if people want to just ask them by unmuting, whatever works best for everyone. No questions. Nice.
I know, right? It's crazy. There's nothing in the chat. Yeah, I mean, please, if anybody has a general question, feel free to unmute yourself and go ahead and ask. This is a good
Sometimes I find
opportunity.
people have questions that come up throughout and then it gets answered on the next slide. So hopefully that's what happened today and it was all really clear, but this is also really confusing and it took me a long time to fully understand it, even as a copyright lawyer. So please feel free if you need any clarification or anything's a little confusing to you.
Yep, somebody's asking for the slideshow, which we will take care of.
It's already in the Longmont Artists Guild inbox, so they will pass that around.
Yep, so if you want a copy, just shoot us an email. I see thank you, very informative. I see a question. What happens upon the artist's death? I imagine the artist would assign copyrights at will, in a will.
If they have a will, yes. Copyrights are property. Copyrights are still in effect even when someone dies for an additional 70 years. So as a piece of property, granted it's intangible property, kind of like stocks or bonds, but those pass with someone's estate just like any other property does. So it'll follow the state law rules for intestate succession if they don't have a will. Or if they do put a will together, they can dictate who gets them. But ultimately, whoever the heir is, whether named in a will or through intestate probate, becomes the owner of the copyright. So at that point, the artist's heirs are in control of the copyright. You need to go to the artist's estate or the heirs, whoever controls that copyright, to get a license during that 70-year period after the artist passes away. And in some cases, especially in music, artists' work becomes more commercially valuable and more popular after they pass away. And it can cause a lot of problems for artists' estates because if they don't have a will, but they do have a lot of kids, then stuff gets tied up and ultimately it's hard to get licenses cleared because none of the co-owners can agree on it. So something to keep in mind for your own estate planning as an artist, that if you want your heirs to be able to handle things clearly, that you address copyright issues in your will too, because it's not something that most estate planning attorneys know about, but it's just as important, especially for artists who are commercially successful and have a lot of material. It's just as important as any other property that would be passing in your estate.
So, Max, I do have a question.
Yeah.
One of the things that was actually brought up when I was younger was for prolific artists that basically do lots of pieces of work, and they were concerned about how much they were spending per item. Now,
On copyright
for
registration?
some of those yeah, for the copyright registration, um, some at the time they were also recommended to possibly bundle their works into like a book or something like that.
Yes.
But I have also heard that dif diminishes the value of the individual copyright as well. Even though even though it's a copywritten piece, the
Yeah.
fact that it's part of a bundled set of artwork, that it diminishes the value of that copyright within that bundle. Does that make sense?
It does make sense, and that is partially true. So, couple things to note here. First thing is that the standard copyright registration form that the Copyright Office offers usually is meant for anywhere between one and a small number, we'll say under 10 works, usually can be grouped together on the same form. Over the years, the Copyright Office has also developed what's called a group registration form, which is a special form meant to register a large group of things all at once. They've taken that a step further and they have group registrations for unpublished works and they have group registrations for published works. And within the category of published works, they only allow group registration of certain very specific types of works. And unfortunately, I've looked into this before. Paintings are not one of those. So you can do that with photography, whether published or unpublished. But most other types of visual art, the group registration option is only there if it's still unpublished. That said, publication, the word publication in the context of copyright law is a very specific term that means that the work is available for sale. It doesn't mean that you've just put it up on your website or that even that you've shown it in a gallery. Generally speaking, public displays do not count as publication, as confusing as that can be. Publication for registration purposes is you actually making the work available for sale in some way. So the work itself or prints are available for sale, something along those lines. If you
If that
haven't done,
is,
yeah,
I was just going to say, if so, how does social media play into all of that?
those are just public displays. If you're
Okay.
using your social media to sell, maybe a closer call, but a lot of times that violates the terms of service of social media platforms anyway. So probably not the best idea to do it that way. But generally speaking, a public display of the work, which can take a lot of different forms, does not count as publication that crosses that line for registration purposes. So if you've just displayed it, you haven't made it available for people to buy it, you haven't sold prints of it, then it's still unpublished and you can register it as a group of unpublished works. And to tie in with Bonnie's question here, the standard application, which again is usually for one or a very small number of works, is $65. The group registration is usually $85. And then there's a third option, which is called a single work by a single author. So if you have no collaborators and for whatever reason you're just looking to register one work, that is actually a discounted rate of 45. And those fees do go up every 10-ish years or so, sometimes more. But this recent fee increase was only a couple years ago, so I don't anticipate that's going to change anytime soon. With Let me see if I'm remembering this correctly. This is something, before I go any further, let me just point out this exact topic is something that is addressed in at least one or two circulars on the Copyright Office's website. So even if you don't remember this conversation, and I'm not going to get every single detail exactly right, those are really good resources to go to before you start that process of registering. uh, so that you understand kind of how this works. With photographs, for various reasons that I'm not sure I fully understand, they allow much larger quantities of works to be registered under one form. I think you can do, whether published or unpublished, you can register up to 750 photographs per application form. So 750 photos for $85, not a bad deal when it comes to registering. And to your point, that type of registration form does not diminish the value, because the Copyright Office still recognizes that even though they were grouped together for purposes of the application, that each work in that application still has its own distinct copyright. Now, the other way to go about it is if the artist actually takes their works and repackages them in some, what they call, a new commercial unit of production, such as putting it together in a book or something like that, that is a different copyrighted work. That you're actually going to the Copyright Office and saying, I'm registering a book of photography rather than a whole bunch of individual photographs. And so in that case, the copyright attaches to the book itself. So that's a situation where I think arguably the individual works are somewhat diminished in value, because the copyright in each of those photographs is essentially derivative of the book rather than a photograph that stands alone. A little bit nuanced, it gets a little bit complicated there, but registration, you're essentially telling the Copyright Office, this is the work that I am looking to register. And so if you are very clear that you're registering one particular painting or a group of paintings and you want them all to have copyrights, then you go that group registration route. But if you're doing more of a retrospective and you want to put out a 50th anniversary coffee table book or something like that, that's a whole different commercial product that you're selling, right? And so then that would have a different copyright there. Trying to think if there's anything else about that to touch on. Oh, with unpublished works, if you're doing the group registration of unpublished works and you're looking to do something other than photographs, like paintings or drawings, I believe you can do up to 10 per application form. Pretty sure that's correct. And then music, they allow 20, so it varies depending on the type of work. There's another question in the chat here, whether artist copyrights are considered to be marital property in the event of divorce. They can be. That gets into other areas of law, family law, that governs kind of how property is categorized for marital purposes. Some states in the United States are community property states, where any property that is acquired or created by either of the individuals during the marriage becomes community property of the marriage, not just one of the individual people. But in states that are not community property states, that is not the case. So non-community property states, the copyright is still owned by the person who created the work and does not automatically become marital property. Obviously, if you have a prenup or something, that could shift that situation. Let me just back up. The basic answer to your question is that copyrights absolutely can be, because they are property. Whether they are considered marital property depends on the specific rules of family law in your state. So since I assume everybody here is in Colorado, Colorado is not a community property state, at least as far as I'm aware. And so generally those are not automatically, the spouse does not automatically have a claim to that property in the event of divorce. I'm not a family lawyer, so I don't really want to go any further than that and say something that's not correct. But it is something to look out for, and I have dealt with a marital property issue with copyrights in my practice. So I have touched on these issues before. But again, because every state is different, it'll vary depending on where the parties live during the marriage and things like that. Anything else? Well, thank you everyone for such great questions and for your attentiveness. I really appreciate it, like I said. And feel free um, to get in touch with follow-up questions, or if you'd like to set up a consultation. I'm happy to chat with anybody about anything involving copyrights, contracts, trademarks, protecting your art, making money from your art, things like that.
Great. Well, thank you so much for your really informative presentation. I'm sure we all learned a lot. So thank you.
Yeah, happy to.
All right. Well, with that, thank you all for attending the meeting tonight. And we still have our art show up at the Great Frame Up. So it's up through March 7th, I think. So stop in and check out all the great artwork there. And we will see you back here in February for our next meeting. All right. Thanks, everyone. Have a good night.